Good evening. Welcome to PoliticIt podcast. We've got Brady Brammer with us today, and member of the House, House District 54.
Correct.
And you've been in there for a while, but now you're actually you're actually running two races at once, right?
Yeah.
But you're unopposed in the House.
Yeah, I'm unopposed in the House, so that one I think I'll win. But I am running a special election for the Senate that is it's Senate District 21 that's been vacated, or that will be vacated when Mike Kenedy wins the U.S. House seat that he's up for.
Yeah, that'd be great. I mean, of course, being a member of the Senate, I'm a little bit disappointed that Mike Kenedy will be leaving us. He's been a fantastic member of our body. He just, there's a guy that,
He's smart. He's thoughtful. He's very principled. He's conservative. He's really everything you want in someone serving your area. They're big shoes to fill.
Yeah. Well, and this is a fairly conservative district, right?
It is. Yeah.
Probably one of the more conservative districts in the state.
I think it is perhaps the most conservative in terms of, if I recall, we have more registered third-party people than registered Democrats in my House district.
In your House district.
Yeah.
In this Senate district, it's kind of the same thing?
It's probably pretty similar.
Oh.
Yeah.
Very cool. So let's talk a little bit about your background.
Yeah.
I mean, you're a BYU student.
Yep, I went to BYU. I have what I call the 3 degrees of glory from BYU, meaning that I did my undergraduate there in American Studies, and then I did a master's in public administration and a law degree, all at BYU. The funny thing is I wanted to go anywhere but BYU, having grown up in Orem, just in the shadow. And so, but it just kind of worked out that I ended up at BYU all
So
BYU
Law School, how was that for you?
It was awesome. Some of my classmates are like, I cannot tell you how impressive they are as people, and having watched them go from being my classmates to watching their careers after that, they're just an incredible group of people. And that is, that's helped me because, boy, they were tough to compete against. And when you're in law school, you are competing.
Right, yeah.
And so that helped me a lot, and they set a really high bar, a bar that I had never been in a bar or had standards that high prior to that. I think the first textbook that I ever really read was in law school. And, prior to that, I could just, read the glossary of terms and kind of just
go to class, listen to the lectures.
I could listen and make it work. And I had good grades and was on scholarship and everything. But it wasn't until I got to law school that it was really, you need to get things together and really know it. And so it was a great experience for me.
So after law school, was it LA you went to?
Yeah, so I went to Los Angeles, and I was with what people call big law in Los Angeles, doing a lot of business litigation. And then I came back to another large law firm here in Utah for 3 years, and then started my own practice with a friend. And I've had my own practice that way ever since about 2015. And ran for office in 2018 and started in 2019.
Well, it might make it a little bit easier being in your own law firm when you're in the legislature, right? Because you have to take off a lot of time to do that.
Yeah, there's a few things that really help having your own law practice. Number one, it's good to be the boss. And you can choose, when you can take time off and when you can't. And you can build your employees and you can build your infrastructure around being able to take that time off. But also, sometimes in a big law firm context, there can be outside pressures to try to influence you as a legislator. There can be clients that say, I don't like how this person's voting, and I'm going to take my business elsewhere unless they change their vote, or things like that. And so even though I've been approached by numerous of the larger law firms in Utah and in nationwide to join them, I've always kept my own practice because I wanted that freedom so that my political philosophy and my votes could remain as true as possible with as few conflicts of interest as possible.
Now let's talk a little bit about your family. I know your wife's very involved with the party, and you have 2 sets of twins. Is that right?
Yeah. So I have 16-year-old boy-girl twins, and a lot of insurance that I pay for their cars right now, or for their car that they share. And then I have
thank goodness they're girls.
Well, one boy, one girl.
Oh, one boy, one girl. Okay.
Yeah, and then I have a 12-year-old little boy, and then I have boy-girl twins that are 7 right now.
Oh.
And so it's a busy time right now. I call it the golden years because we've got all 5 at home, and in a couple of years we'll lose. 2 of them will go off into the world, and it'll be a very different household. But it's pretty awesome right now.
Yeah. Well, and your wife Nikki is pretty supportive of your legislative stuff, and
yeah, there were 2 times where I went to my wife thinking that she'd shut things down, and I had kind of hoped that she'd shut them down. One was I was going to Spain, and I said, "Should I run with the Bulls?" And she was like, "Yes, run with the Bulls." So I ran with the Bulls, but I was kind of hoping that
she might say, "No, Brady,
that's too dangerous." No, I was pretty scared running with those Bulls. But the other time was when I said, "Should I run for office? I'm being recruited to run for a legislative seat." And she said, "Yes, absolutely, you should." And it was a really pivotal moment in our relationship because she was always the person that everyone liked. She was like her class president and everything that way. She's way easier to like than me. And so when I started running, I just said, well, if I'm going to run, I need you to do it with me. And so she came to everything, and everybody fell in love with her and then voted for me. She was my secret weapon, and she always has been. And even since being in office, she got involved with the party, and she's really good at it. She was the chair of the state convention this last year, which is no small feat. I mean,
no, that was a tough convention.
It was a tough convention, and the rules that are imposed by both the facility and by the party are really hard for the chair to manage. And she did such a great job and did it with grace. And although conventions are always difficult, there's always technology issues. There's always, voting issues and controversy and things like that. But you've got to have a stable hand at that rudder, and she did a great job with it.
Yeah. She's been involved with the SEC too, right?
Yep. She's been Central Committee. She's been part of the State Central Committee, and then she's also been the communications chair for a couple conventions before chairing.
Well, and I know in the National Convention she had a role in that too.
Yeah, she does everything. She's just great. She's so smart.
That's good. So what got into you, Brady, to want to run for the Senate seat? I mean, you have a pretty important job already in the House. I mean, you just got put in as Rules Chair, right?
Yeah.
You're very well respected in the House, I know. And so what really motivated you?
There's a couple of things. Number one, I was encouraged to run for Senate by people that felt like they needed that experience in the Senate, so that we didn't have a drop off in our area when Mike left. And there were people that I look up to. And then there were, and that included Senator Kenedy. He said, you should throw your hat in the ring on this, and then there was also the issue that really pushed me over the edge were the recent decisions by the Utah Supreme Court. And that's an issue I follow very closely.
Yeah.
I've been following the nominating commissions and working with Senator Colomore quite a bit on trying to redo some of the nominating process because it had gotten undercover partisan in the nominating process. And what I mean by that is there were conservative judges that they were refusing to interview and that they were playing keep away from the governor. So the governor didn't have a chance to nominate conservative judges. And so, Senator Colomore was great on leading out on that to redo the nominating process so that wasn't continuing to happen. But when they issued these recent decisions, that would kind of push me over the edge to say there's something going on where the courts do seem to be taking a more activist role than they had previously.
And it doesn't make any sense when we have a supermajority Republican state, right? People can't believe that would happen in Utah.
Yeah, and in the past, the courts have been pretty good about, they're meant to be the umpire in the baseball game. They're meant to stay behind home plate, call balls and strikes. And the problem that we have is, and we've known for a while that the political persuasion of the people of Utah versus the bench it has the highest delta in the country. Okay? And meaning that the judges are far more liberal than the population. But normally, if they're calling balls and strikes, that's okay. But then it gets to a point where the judicial philosophy starts to follow to where, they're trying to find ways to say that, the legislature meant something or the Constitution means something that it didn't mean. And so what they're doing is they're stepping out from the umpire's role and they're stepping into the batter's box more often than they ever have. And the initiative decision was a really quite a wake-up call for me in perceiving what they were doing and how they were doing it. Why the Senate then? I think you need to explain to people just a little bit about why it's different in the Senate than the House. Yeah, and so and to be honest, I try to work with the courts because I have a vested interest in making sure that they function well, that they have enough funding to do their job, enough staffing to do their job, and so that they can be a great judicial body, because our businesses and our citizens rely on that court system. It's a proper role of government, and I want to see it succeed. But on the House side, I can help with some of the funding and with some of the things like that. But on the Senate side, I have an opportunity to participate in the confirmation process, which that means that you're starting to, you have a role in choosing whether or not a judge is confirmed that is chosen by the governor. And, I felt like if I didn't have a say in that we're at a higher risk of just continuing on like we have been. And we really need to push back, or at least push on the governor to choose judges that are going to have a more restrained judicial philosophy. Yeah, that makes a lot of sense. Hey, we're going to take a break and we'll come right back because I want to continue this conversation. All right.
Hey Siri, how do I get to the state capitol?
John, the fastest way to get to the Capitol is to make a lot of empty promises, to get help from special interest groups and endorsements from politicians. You will also need to buy a better suit.
That's not going to work for me, Siri. You need to find another way.
John, listen to me. If you're going to win your race, you will need to play the political game. You also need to use more hairspray and buy a golden retriever. Also, a new phone case would be nice.
That's enough of this.
John, are you there? Did you just leave me on the road? Fine. Keep your principles, John.
My name's John Johnson. I'm not running to be part of a system, and I don't owe anyone special favors. I'm running to listen to and work for you. I'm running to get results. Welcome back to PoliticIt. We've got Brady Brammer here, and Brady, we're just talking about you running for the Senate seat that's being vacated by Mike Kenedy when he joins the U.S. Congress, and we started talking about what motivates you, and this Supreme Court decision that just came out, by the way. Let me ask you a few questions about that, because I'm not a lawyer, right? I like to play one in the legislature, but I'm not a lawyer. But when I read the Constitution, the section about reapportionment, about boundaries, right? To me, it's pretty clear that is the domain of the legislature. Yeah. I mean, to me, it's clear, and I don't know if I'm missing something in the language. No, Article 9 is quite clear that the legislature shall vote on the boundaries. What the Supreme Court is trying to say is, but the people can, through initiative, dictate the criteria upon which they can vote. Now, the Constitution is silent as to that. And one of the problems that the Supreme Court has put us on is we are barreling towards a constitutional crisis, because what will happen under the Better Boundaries Prop 4 initiative is, if the legislature doesn't adopt a map by the redistricting by the Independent Redistricting Commission, so the legislature votes no. Now,
it already has an unconstitutional provision, which is based on Article 5, the distribution of powers. And that says, Article 5 says, there are these distinct group bodies of government, legislative, executive, judicial. And if anyone tries to exercise the powers of the other, then you've got a problem. Well, if we reject a map by the Independent Redistricting Commission, and then the court says, no, but you need to adopt a substantially similar map, or you need to adopt that map. Well, at that point, the court has stepped into a realm that belongs to the legislature clearly under the Constitution. So if we just adopt another map that we choose, and the court says we don't like that one either, and then we adopt another one, and it just goes back and forth because they can't make us adopt a map, and we don't have to adopt their map. And so, it creates a really bad precedent.
They've created this quasi-constitutional, in my view, okay, looking at this, they say, okay, we've got this initiative that only passed 4 counties by less than 1%. And those 4 counties are Salt Lake, Summit, right, Carbon, and Grand County. Okay, now what's similar about those counties? Well, there's a lot of Democrats in those counties, right? And so you've got this initiative that barely passes, and now all of a sudden the Supreme Court has come in and said, oh, because this reforms government, unless the state has a compelling interest, right? Then that should take precedent over the very clear language of the Constitution that says, no, the legislature is responsible for the boundaries. But they've kind of taken this other piece and they say, yes, but citizens have the right to reform government.
And that's part of the problem. So there's 4 primary problems with this initiative decision. The first is they said, okay, we're going to tie the initiative process to the Alter or Reform Government Clause. Well, Alter or Reform Government Clause was in the initial Constitution. Okay, the initiative one came later. So what did they mean at the time of the initial Constitution? Well, they only meant the only thing they could have meant was the process in place in the Constitution, which was the ability to amend the Constitution at the time, which was 2/3 of the legislature and a majority vote of the citizens. So that, if you're looking at an originalist intent, that's what alter or reform meant. We can't get in the way of that. But the court said, no, we think that this initiative clause went back to that and pulled it forward, another 6 years in time and actually meant something different. Okay, so let's take that and let's grapple with that. Well, now we've got, okay, well, what is the express language of the initiative clause? And there is no express language limiting the legislature. So what did the Supreme Court do? They didn't say, we look at the way that the legislature was debating this at the time because they don't have any records of it. But they said, even though no other jurisdiction in the United States of America has said that a legislature is restricted in this way, we're going to assume that it was, because one other legislature in South Dakota had adopted language saying that they're not restricted, and because that language wasn't adopted here, then that means that they were not intending to allow the legislature to restrict the initiative process or to reverse the initiative. Well, that's not the way that any other legislature has worked. There are 21 states with referendums, and of those that limit legislatures, they have express language in their constitutions that say the legislature cannot, or the legislature can only do it for a certain, or cannot for a certain period of time, or that the legislature cannot do it unless they get a 2/3 majority. So there's a problem that there's no express language there that the court read into it. So that's the second problem. Third problem, well, it actually contradicts the express language that is there. Because if you go to the next clause on referendums, the legislature was wise enough to say, but the citizens cannot overturn the legislature unless there's unless they get less than 2/3 in the legislature. Then, if we get over 2/3, there's no referendum.
Right.
So what they have to assume is that the legislature knew how to build in limits in the referendum one that was passed at the same time, but did not know how to do it adequately in the initiative one. And so they ignored the express language of the Constitution, so that's the third. And then the fourth is they ignore the idea of what would a legislature actually do in voting on the 2/3? Would they have included no language and just left it to the courts if they thought that this was actually limited? I don't think so. Because before you can submit it to the people, you have to get 2/3 of the legislature on that amendment. And do you think it would have gotten a 2/3 vote if they said the legislature cannot amend any initiative? I don't think so. That's a really far jump in logic to get there. And I think the concern that I have is that the court lost focus on the principles here because they really, really, really wanted an independent redistricting commission to have their way. And and we've seen this in the past where bad facts make bad law. The courts wanted something, and so they made a lot of bad law to get there. And I think they left the principles that are out there that tie to what did the language mean at the time. And they had to go searching for other language in South Dakota at the time and assume that a false contrapositive, meaning that because it was there, that it must not be here, in order to get there. There's just so many gaps and logical fallacies in how they got there on the initiative. And I think it's because they wanted to step out from behind the batter's box and they wanted to step into the batter's box. They wanted to be the batter, not the umpire.
Yeah. Well, and essentially, since the legislature now cannot modify an initiative unless there's a compelling state interest, who makes the decision of the compelling state interest?
Well, the courts do.
So does that now shift power away from the legislature to the courts?
Well, and it's a short-sighted shift of power. These redistricting cases have come up to the U.S. Supreme Court throughout the entire history of the U.S. Supreme Court. And the U.S. Supreme Court has been wise enough to say these are political issues that we don't get involved with. Because once you start playing politics, and that's what this is, then you are subject to the politics. And that's the problem. And that's the thing that makes me most worried about the court is when they start playing politics, they open themselves to be played with in terms of the separation of powers and what happens. Because I don't think they can sit in the ivory tower, to borrow from academia and say, we're going to opine on these things and tell you what things mean when they're actually playing the game. And so now they're in the game. And that means that, you have a pitcher on the other side and we'll see how it goes for him. Makes me worried for the courts, to be honest.
Well, it makes me worry for the citizens of the state because now, do we really want initiatives that barely pass? Do we want law to be dictated by, let's just say, Salt Lake County?
Yeah, I mean,
right?
I think that you'll see initiatives related to abortion. I think you'll see initiatives related to alcohol. Costco just ran an initiative in Michigan. So you'll probably see, one thing that would be interesting is an initiative that says that the legislature cannot impose an income tax. That would be a really interesting one, because now how does government get funded? How do our schools get funded? Those initiatives can arguably be something that alters or restrains government, or alters or reforms government. And so the courts left it so wide open as to what that means that now they're going to be picking and choosing unless they find some clear, cogent way to give us an idea of what that means pretty quickly. Then they've just lined themselves up to where every initiative and every legislative reaction to it is now subject to a lawsuit.
The sad thing from my perspective is that it's very easy on the one side to say Proposition D was a bad thing because it's simply the legislature trying to grab power. And that's an easy thing to sell, right? That's an easy message to sell. How do we explain the message on the other side? Because that's not what's happening, in my opinion.
Yeah, I think it has always been a challenge for legislatures everywhere to have good PR. We're not good at it, and we're structurally not good at it. What we are good at is making hard decisions, making lots of hard decisions, and still getting reelected. That's the way that legislatures work. I don't know of any legislature that has like a great approval rating nationwide in any state, or even the federal has an abysmal approval rating. And so getting that message across is going to be hard, and it's going to have to be post-legislative messaging, because, and that was part of the problem is, the court released their redistricting decision almost exactly between the legislative sessions to create as much distance from that decision and any legislative session as they could. And it happened to fall in July, which means that we had about 15 days to figure out what to do with that by the time we got to interim and could run a constitutional amendment. And then the courts took an interesting position on the notice, and publishing in the papers that really hasn't been adhered to, and they may have just invalidated a ton of amendments, but they didn't provide, they put themselves in the batter's box because they didn't provide any analysis as to what to do with unchallenged amendments on the ballot, like B and C this year, and what to do with previous amendments that have been passed, and whether they will overturn the will of the people based on a notice provision for newspapers that haven't existed for a long time.
Yeah. Yeah, because they basically said it has to be published, right, in a newspaper. And we don't even have a statewide newspaper that publishes every day.
No, we don't. And
there was no way to meet that standard.
No, there wasn't. And most other states use what they call a substantial compliance standard, whereas our court adopted a strict compliance standard, which is an odd decision because Amendment D attacked their decision. And so again, they got into the batter's box. Again. And I'm not saying that the language on Amendment D was perfect. I think it was a little too strident.
Right.
I don't know that it's the proper role of the court to get in and mess with that. That's something that could have been debated within the public forum.
Right.
And that would have been appropriate. I don't see the courts getting into political fights when somebody uses language that they don't like or that they consider deceptive. Welcome to every political campaign that you've ever seen that's really, that has a little bit of conflict in it.
Right.
The courts don't get into that. And so here the courts got into an issue because it was pushing back on a decision they put out.
Okay, so what I want to do is I want to bring this back because I think you've made a very strong case why Brady Brammer for this position. Why is it important for you to be part of the Senate? Let's come back to that issue because that's what motivated you.
No, it is. It was kind of it really was I had people talking to me before the court decision came out, but this pushed me over the edge to do it. I have two motivations. Number one, we need to get that right. We need to get the courts back in the umpire's box. And that's going to take a lot of work. But number two, we can't decimate the courts in the process of doing it. They need to continue to be a functional and viable path for people to receive justice. And if we don't protect them from the political firestorm that they have opened up, and do so in a reasonable way, then we're going to do a disservice to our citizens. So that's a tough line to balance, and I think that it's something that as someone that's in the courts a lot, they're going to not like me for beating them up on getting into the batter's box, to use that analogy way too much in this interview. But they are going to like me because I can look at where their core needs are and still say, look, I know we're fighting over this. You've got to deliver justice, and we need to fight so that they still can.
Well, I like the idea, and tell me if I'm wrong here, but you're running in one of the most conservative districts in the state.
Yeah.
Right? Which would put you in a unique position to help us vet judges.
Yeah.
Right? Because let's face it, Utah's a conservative state.
It's a conservative state, and I am, I've always been able to take strident conservative positions because my district has always supported me. I have a great, my district is a highly educated and highly conservative district. And what that means is, and our party platform in the Utah County side of things, which is where my delegates are and where my voters are, is that we push back on judicial activism. In all forms, we push back on judicial activism. And so I am very well supported to make that argument and survive politically while I do it.
Which makes that an ideal place for our for people who are going to vet our judges to come from.
Yeah, yeah, and so that's the hope. It's going to be a tricky issue that will take, you don't make changes in the judicial branch, both in terms of personnel and structure, without taking a long view. It's going to take a lot of hard work to get there.
Right. Well, I appreciate that insight. This has been a subject that's been on my mind, because I'm worried about the shift in power that's occurring. I mean, you look at California, you look at Colorado, both of those states really have been turned blue through an initiative process, I believe.
Well, and I think you're right. They've turned blue through an initiative process, but additionally, they've done a lot of dumb things through initiative processes. And and in California particularly, it's egregious. And the court adopted the California model into Utah without that language that's that's typically needed, that is there in California, but isn't in our Constitution. But the court adopted a California model. If we don't, I don't think that's what the citizens of Utah want. I don't think that they necessarily want a pure democracy on more and more issues. Their voter pamphlet, they don't want it to be 30, 40 pages long of what they're voting on. When I lived in California, I saw that personally, and we would try to remain educated, and we would, hold and go to citizen forums where we'd go through each ballot initiative one by one and talk about the pros and the cons and everything that way. And, and I remember the Prop 8 battles, if you remember, on gay marriage stuff. And, it can be used in a way that is far more manipulative and less thoughtful than any legislative process. And so we have to be really careful, because I don't know of many societies that have done well in the long run with a direct democracy system on policy. It's a really hard system to maintain, and we shouldn't do so lightly. And I think we did lightly.
So if you could make a pitch to these delegates, what is that major pitch?
The major pitch, there's a few. Not all of them care about the judicial stuff.
Right.
I care deeply about that, but
that's your motivation.
That's my motivation. But the pitch that I would have is, I have been consistently conservative for 6 years in the House, and I have been consistently effective. And those are not always the same thing. Sometimes you can be conservative and you don't bring anyone with you. But what I have specialized in is, I help people that are maybe on the fence be more conservative when it comes time for the vote. I will help explain issues in a way that they can understand why that makes sense when they zoom out and they see the principles behind what's underlying this decision. And I can bring people with me, and I've consistently brought people with me. If you've watched the House, you've seen that it has consistently moved towards a more principled place for the 6 years that I've been in there. And, I've always been the person who, on most of the controversial bills, you'll see that I'm the last one that speaks. And that's because I rebut all of the non-conservative arguments, and I help people understand why this vote matters in the larger context of the principles at play.
Very good. I appreciate you coming in and giving some more insight to that. After I had Rob Bishop here last week, I just thought, I'd like to bring Brady Brammer in here to talk about this a little bit, because I know this
Rob
has been
was
something
awesome.
Oh, he did an awesome job with that, right?
Yeah.
And what was cool with him is that he was actually on the inside of the
Independent Redistricting Commission.
Yeah, and ended up resigning from it.
Yeah.
So anybody that wants any further information ought to go watch that. But appreciate you coming in, Brady.
Yeah, thanks so much.
And good luck with your race.
Hey, thank you so much. Really appreciate it.
Yeah, thank you. We'll see you guys next week.